I, the presiding judge and judges of the Court of Appeals of the State of North Carolina, Oyez, oyez, oyez. The Court of Appeals is now in session. God save the state and its honorable court. Be seated.
I think my mic is on now. I've got to turn on the green light. You don't want to test your mics real quick. Make sure you're good.
Am I on?
All right. Well, good afternoon. Welcome to this special session of the North Carolina Court of Appeals being held here at Elon University School of Law in Greensboro. I am the head of your panel today, Judge Hunter Murphy. To my right is Judge Toby Hanson. To my left, Judge April Wood. We want to thank the faculty and students here at Elon for being such gracious hosts, for presenting this opportunity to come here to get back to a little bit of a sense of normal and hopefully have some great arguments this afternoon. The first case we'll be hearing today North Carolina Farm Bureau versus Carpenter et al. And then we will be with the appellant. And I'll be keeping time here at the bench. I'll try to give you a 5-minute warning if that's how much you want to reserve for rebuttal. If it's more or less, I'll try to adapt to that as well.
I'll say 15 minutes for rebuttal. Please, the court, my name is Walter Brock from the Wake County Bar. It's a pleasure to be here before this panel on the road. I'm here with my co-counsel, Bill Lipscomb. From Wilkesboro, we're proud to represent North Carolina Farm Bureau in this insurance declaratory judgment action. We're up here on the field. We're asking this court to reverse and remand the decision of the trial court and remand it for entry of judgment, finding that there's no duty to defend and no coverage for the underlying cases that arise out of the Legionnaires outbreak at the Mountain State Fair up in Hendersonville. The facts in this case are tragic because multiple people were sickened, 4 people have died. But for purposes of the insurance coverage issues, the facts are really quite simple. In our appellant's brief, we prepared 2 tables that provide a synopsis of the key pleadings in the underlying cases, as well as the key pleadings in the declaratory judgment action. And I don't think any of that summary in those tables is an issue here. The questions really boil down to some legal issues, I think. About as remarkably focused on legal issues as we have a chance to see in our practices. In this case, it's of course up here on the denial of a motion for judgment on the pleadings based upon the answers of the party, based upon the underlying pleadings and the answers of the parties to the declaratory judgment action. In this case, it's uniquely, I suggest, appropriate for judgment on the pleadings. And the duty to defend being an important issue, obviously, giving rise to a substantial right and a right of immediate appeal from the denial of that motion.
So I noticed in the that there were some differences in the factual allegations between the cases, primarily centered on whether or not some of these plaintiffs had actually entered the building versus merely attended the fair and been in the vicinity of the building, I guess. What impact does that have from your perspective on the insurance policy and application.
It doesn't matter, Your Honor, and for these reasons. These are the determinative facts for purposes of application of the fungus and bacteria exclusion. One, the first factor being it's not in dispute. There is such an exclusion. It's admitted. There's no question about what that exclusion is. Secondly, and it's not in dispute and it's agreed by the parties, that the Farm Bureau insured Carpenter's hot tub was on display for marketing purpose in the Davis Event Center. That's not an issue. It's not an issue that numerous people were sickened and 4 died from exposure to Legionella, and they attended the Mountain State Fair. That's not in dispute. And plaintiffs necessarily alleged that Carpenter's hot tub, which everybody agrees was in the Davis Event Center, was at least one cause of the Legionella outbreak. Now, I understand that those cases are still underway, and the exact cause of the Legionella outbreak is, I guess, still in dispute about that. But for purposes of a duty to defend, we accept the allegation that this hot tub was a source of the Legionella, and they have to make that allegation. And so those core facts are determined for purposes of insurance. It doesn't, for example, the appellees raised the issue that, well, some people may not have been exposed in the Davis Event Center. And we say, based upon the plain policy language, that doesn't matter. What is essential that the plaintiffs have to allege and prove is the hot tub was a source of Legionella. It's not in dispute that it was in the Davis Event Center. And it's not in dispute that it was there for purposes of display for marketing purposes.
Let me ask about the purposes versus the intent of the good or product. When I read this language in the exception, it's short, I'll just read the whole thing out. This exclusion does not apply to any fungi or bacteria that are on or are contained in a good or product intended for bodily consumption. Assuming that we agree with the appellees that a hot tub could be for bodily consumption. I know it's another issue for argument.
Right.
But assuming that, why isn't this a good or product that's intended for that purpose? It can't just be merely that at the time it was only there for marketing and display purposes, right?
Well, no, Your Honor, I would respectfully disagree. It's what is intended for at the time of the exposure. Because, for example, we've got an example of another case where there's a fountain in a hospital lobby, okay? Some fountains could be intended for playing in, right? They could be intended for bathing in, but it wasn't there and it wasn't then. Same with the hot tub on display at the Mountain State Fair. It wasn't then intended for bodily consumption. If it doesn't mean that, then the exception.
But the fountain issue there was, I think the Wisconsin court phrased it as an art installment. It wouldn't ever be used for somebody bathing in or playing in the fountain, right?
Well, that's true. But my point is that a fountain, the purpose of a fountain could be used for bathing in. One could put it in a different place at a different time. And we know of parks where fountains are set up so kids can bathe in them and cool off in the summertime. So I submit that a plain language reading of it means what that good or product is intended for at the time of the event that is creating the liability exposure.
So would you contend then that the displayer, the Carpenter wasn't going to allow people to try out the product because there were hot tubs, right?
Well, they were on display. The regulations of the Mountain State Fair are not in the record here, but it was on display for sale. And importantly, there's no allegation otherwise. And Carpenter admitted in his plea that it's not all alleged or contended otherwise, that they were there for marketing purposes. They were on display for marketing purposes. Now, the duty to defend is based upon the allegations that are made, not some that might be imagined that could possibly happen. And I would submit, one could imagine that somebody jumped in that hot tub and had a party, but that didn't happen, and it's not alleged it happened. So the duty to defend is based upon the allegations of the underlying complaints.
I want to go back to this temporal aspect a little bit. If, say we're dealing with a hot tub that was inside an enclosed hotel. Inside hot tub you see all the time, holidays and whatever. If the pool closes at 10 o'clock, if somebody comes in and sits by the pool at 10:03 and catches Legionnaires from the hot tub, would it be your position that the exception to the exclusion would not apply in that situation just because this wallet was closed? So that one is really decorative.
First, if you will permit me, I don't want to concede that even bathing in a hot tub.
And I understand, yes, sir.
Right, but I think there could be a different temporal situation there, because that was in place for purposes of bathing. It was just closed, right? Some tapes were up or something marking it off. But here, there's no allegation that it was ever put into use for bathing, ever intended for bathing. And so that there could be on the margins, Your Honor, I'll acknowledge, I think that's a nice example. But here, there's no such allegation that there was any circumstance under which these hot tubs on display at a state fair would be used for bathing.
Well, if they're on display for marketing purposes, I'm thinking, I go to Best Buy, they might not want to sell me the last TV, but eventually they're going to sell that last TV. They're using it as a display unit. So at some point, it's going to be for consumer use, whether it's on clearance or whatever at the end of its display time. There's nothing special about these hot tubs that were out for marketing purposes that would make them only display type models. So they would never be ready for resale later, never ready for a different type of marketing or exposure, right? They're just run-of-the-mill hot tubs just from the general inventory.
That's right. And if you have a hot tub in a retail establishment that is never there, never intended for bathing in, I would say it would not fall within the exception. It would not be a product or good intended for bodily consumption.
And what do you, we're talking a lot about hot tubs being the product of good. There's an argument in the appellee's brief about the water being the product or the good.
Yeah.
What's your response to that based on the allegations and the pleadings? If the pleadings are broad enough to incorporate both potential theories.
Right. Well, in this particular situation, the water would not be a good or product because that was not going to be sold under any circumstance. It had to be drained out for the hot tub to be removed. So the water in the hot tubs on display would not even qualify as a good or product because they weren't there to be used, bathed in, sold, consumed, or anything. They were there as part of the display. The hot tub itself, if it were sold, would be carried on, but not the water in the hot tub. So what I think it's important to do, and is to focus on the fundamentals of what our Supreme Court requires us to do when we're interpreting an insurance policy. And what's sauce for the goose is sauce for the gander. The insurance companies have to live with this rule, and those who are claiming an insurance policy have to live with this rule. We must deal with the plain language of the policy. We must read that language as it's used in its ordinary sense in an ordinary conversation. We must do that. Every word has to be given effect. Every word has to be given effect. And when our courts have strayed from that, then the Supreme Court has required a course correction. One of the most recent cases was the Martin case from the Supreme Court dealing with the residents of a household. the court started going into all these abstract factors about what made you a resident household or not. Supreme Court brought that back. Did you intend to live together? Basic common sense. Waste management, which is, you know, one of the most fundamental cases on the duty to defend. I haven't argued that case. And that was an issue of an exclusion with an exception. The exception was for a sudden and accidental leak. And the argument there was that a landfill that had been leaking for decades, that was sudden and accidental because it was fortuitous. It wasn't intended. Right. And the Supreme Court said, no, sudden means what sudden says. Sudden and accidental. And the Gaston County dying case is another one where the courts imposed this concept of a trigger of coverage is when the damage is discovered. And the Supreme Court said, no, it's when the damage happens. That's the policy.
So one thing that I always find myself kind of thinking about in these insurance coverage cases, you know, given those sort of standard rules of interpretation, is that there are two pieces to an insurance coverage case, right? There's the duty to defend, and then ultimately there's the question of, is there coverage?
That's right.
And broadly speaking, I think you'd agree that the duty to defend is generally considered to be broader necessarily than the duty to cover.
That's true, but I think there's a misconception about what that broader means. That broader means that if the allegations that they make are proved to be true, and that would be covered, then it's broader than the obligation to defend, right? Because they may not be proved to be true. So it doesn't mean that any scenario you can imagine creates a duty to defend. And there's in the Harleysville case is very good on that. We cited that in the brief. And it tells us, let's focus back on what's alleged. What's alleged. And if they prove those things that are alleged, would that be a covered loss? So that's why the duty to defend is broader than the duty to defend. And I probably got you off.
No, thank you. That's exactly what I was trying to draw a little bit. Is that distinction between the duty to defend?
I think we get off track when we start saying, well, there might be some scenario of facts that might be covered if we could imagine some things, and maybe so, but they're not alleged in this case.
And we're coming up on your 15 minutes. I've got one more question for you. We'll give you your full 15 minutes, but in your opening brief, page 9, you asked us to take judicial notice of the website from the U.S. Department of Health and Human Services. Two questions with that. I don't see any case citations or record cite. Was the trial court asked to take judicial notice of that? And also, is there any case law on our ability to take judicial notice on an appeal from a judgment on the pleadings alone?
I believe that. I believe the pleadings in the declaratory judgment action acknowledge that Legionella is a bacteria. I believe that's admitted. So yes, we think it's common knowledge that Legionella is a bacteria, but I believe it's also acknowledged in the pleadings. I know there were a couple of allegations, a couple of complaints that alleged Legionella was a virus.
Right. There's some difference in the complaints on that, and I think the appellate brief comes close to a concession on that issue. But I just wanted to, since you did include this part, asking us to take judicial notice, I wanted to see if it was proper for us to do so, and if the trial court was asked to do so.
We didn't ask them to do that. I don't think that was ever raised as an issue. I think it's cleared up to the extent there's an issue about it by the allegations and admissions of the declaratory judgment action pleading, where Legionella is acknowledged as a bacteria.
Thanks, sir. You'll have 15 minutes for.
So I believe my 15 minutes are up. So thank you very much, and I'll be back.
Thank you, sir. Good to appellate. Mr. Brooks.
May it please the court, Christopher Brook for 70 claimant defendants who contracted Legionnaire's disease at the 2019 North Carolina Mountain State Fair. Are named in the form of the judgment action. I'm joined by my colleague, Richard Ghosh, today. I'll also be arguing this afternoon. on behalf of defendant Carpenter, who the co-defendant is named defendant in the underlying lawsuits. Defendant Carpenter displayed and operated hot tubs, which Rock spoke about at the fair, and had insurance coverage through Farm Bureau. He also agrees that victims' pleadings trigger the duty. I'm going to focus this afternoon on the consumption exception, irrespective of whether the bacterial exclusion applies. The consumption exception to that exclusion triggers the duty. To start, I'm going to pick up on something that Judge Hanson was talking about just a moment ago, and Mr. Brock was talking about a moment ago. The question before this court is not whether the victims have established the duty to indemnify or liability. The question is whether the pleadings, taken as true, liberally construed, viewed in the light most favorable to the claimant, with the benefit of permissible inferences, and bearing in mind that coverage exclusions are narrowly construed, provide even an arguable basis for coverage per the consumption exception. Here, the victims pled that defendant Carpenter was operating his hot tubs in the Davis Event Center at the fair. Part of his marketing pitch was not to show a picture of a hot tub that was operating, not to have an empty hot tub, but to have a hot tub that was circulating water. This marketing pitch was successful. Victims visited the hot tub. Victims lingered near them for extended periods of time. Victims spoke with salespeople associated with the hot tub. One married couple who subsequently got sick bought a hot tub at the fair when they visited. And of course, the victims alleged that they inhaled aerosolized water from the hot tubs containing Legionella, and this resulted in them contracting Legionnaires.
So I asked Mr. Brock this question too about, with all these various claimants, as I understand it, there were some differences in the allegations made as to whether or not, for example, a particular plaintiff actually entered the building and actually saw the actual hot tub. Do we need to parse out these different complaints, or how does that roll into your argument as it relates to the actually circulating around the hot tubs and inhaling the?
For the purposes of the consumption exception argument that I'm making today, you don't need to parse out the complaints because all of the factual allegations are not entirely the same in every complaint, but the fundamental allegations are the same. If you were to go into the bacterial exclusion, which again you don't have to do to rule that the duty to defend is triggered here, you might have to look a little bit more deeply there. Originally, in the initial brief, Farm Bureau argues based on this exposure language in the bacterial exclusion. I think we responded in the response brief, Judge Hanson highlighting that not everybody was in the Davis Event Center. They seem to now concede that point. They moved their argument to the presence language. I don't want to dwell too long on this. But these hot tubs are not like the hotel hot tubs. They don't live at the Davis Event Center. They go in and out of the Davis Event Center. They're not present for the long term in the Davis Event Center. Is it possible that they were transported out on an evening to evening basis and that somebody was exposed to Legionella during that? There are allegations about the maintenance of the water that occurred in or out of the Davis Event Center. So the presence of Legionella is not exclusively based on them being operating on the floor. There's a different sense in which Legionella, separate and apart from that, could have been present at the fair more broadly. But again, our argument doesn't rise and fall on that. The court doesn't even really need to resolve that. It must go to the consumption exception. And based on the pleadings that I just talked about, that are common to all of the complaints before in the underlying actions, these pleadings allege bodily injury as a result of a bodily interaction with the hot tubs. And that fits comfortably within even Farm Bureau's impermissibly narrow definition of bodily consumption. Again, Mr. Brock talked a little bit about the bodily consumption exceptions, so we're all on the same page. In pertinent part, it reads, this exclusion does not apply to any bacteria that are on or contained in the good or product intended for bodily consumption. Judge Murphy asked, what is the good here? One way of conceptualizing the good is as the hot tub itself. the case law in general considers the hot tub water as being the good. And before Mr. Brock argued, I understood Farm Bureau to concede that point. I'll read from page 9 of the reply brief. Farm Bureau does not dispute that the hot tub or its water are goods or products with economic utility. So I understood that they conceded that this hot tub water was a good. That's certainly how the case law more broadly, when it deals with hot tubs, looks at what is a good. And that makes sense.
Although I think in fairness, I think Mr. Brock's point was a little more narrow than that. It was not saying water is not a good or water is not consumed. I think it was just for purposes of our analysis, we should focus on the hot tub as the good at issue rather than the water. If I understood the argument.
Well, the argument today that he was making,
Yeah.
I think the argument in the reply brief on page 9, and again, I would encourage you to take a look back at that. It seems like a broader concession. But beyond that, the broader case law is clear here, and the dictionary definition of a good says that a good is something that has economic utility or satisfies an economic need. And that is the definition that has held sway in this hot tub Legionnaires' disease case law. Soliel talks about the water being the main attraction for the amenities. Speaking of hot tubs, Westport notes that water is integral to a hot tub's appeal. So, you know, if water is conceptualized as Murphy as the good, the question would be, was the water intended for bodily consumption?
You know, when we're talking about case law, we're talking about cases from out of state, exclusively or maybe some federal cases if I'm recalling correctly. But as you've probably seen in cases I've written and oral arguments in the past, I'm very hesitant to rely on a case law that doesn't come from judges of this court or the Supreme Court. What about these cases in their analysis is so persuasive, other than they give definitions, these definitions that one party may like more than the other?
I think you're totally right. These are obviously just persuasive authority. I also should note, and I did not know this already, I don't know exactly when my time is going to run out. So if you could,
You're only about 8 minutes in, so you're doing well.
You know, it seems like 40 over. If you give me 5 minutes warning, Judge Murphy,
I'll be happy.
Appreciate it. You know that I will be up here for the remainder of the afternoon if I'm allowed to do that. The reason that this persuasive authority is particularly persuasive is the fact that the way we interpret coverage exclusions in the state and insurance coverage exclusion in the state, we look as to whether there's ambiguity. If there is ambiguity, then we take the most insured friendly, reasonable interpretation of the term. And yes, none of these cases are binding, but with the exception of one case, every case that has been cited by the parties dealing with hot tubs, dealing with Legionella, has said that bodily consumption is an ambiguous term. And therefore you turn to what the most reasonable insured friendly interpretation of that term is. I think that makes good sense, and I think that's about as powerful as persuasive authority can be. Persuasive authority coupled with the very manageable standards that we need to clear here, which is essentially to establish some sort of level of ambiguity. And when you have court after court say 6 times that there's ambiguity, I think that doesn't establish the fact that it's supposed to establish.
And remind me, because I'm not looking at the language in those various policies either, but is policy language in those cases identical or is it similar?
I hesitate to say identical because then Mr. Brock will say it up and we'll find something that's a little bit different. Sometimes the language is bodily consumption. Sometimes the language is consumption. That has not been determined for this sauce. And more broadly, like the complaints, the consumption exceptions have a similar thrust, operate in similar fashion as the definition. Using even Farm Bureau's own eat, drink, use up, consume definition, these pleadings fall comfortably within that. Farm Bureau essentially interprets bodily consumption to mean ingestion. Here, the victim's very illnesses speak to ingestion of what we would contend the good issue is, which is this hot tub one. Moreover, this ingestion was not an accident. It was not happenstance. It was the point of defendant Carpenter's display in the Davis Event Center. Defendant Carpenter's trying to sell hot tubs. The most effective way of selling hot tubs is not a picture of a hot tub circulating water. It's not an empty hot tub, not circulating water. It's one circulating water. So patrons can feel its heat. So patrons can sense its pressure. So patrons can have that refreshing mist on their skin. And yes, so patrons can ingest that refreshing mist. So even under the narrowest definition of consumption, Farm Bureau's arguments made. Turning to how, and this back to the point, Judge Murphy, about why these other cases are so persuasive, turning to how our courts actually interpret such insurance provision and such pleadings underlines the extent to which Farm Bureau's arguments miss the mark. First, no court interpreting a consumption exception has in a hot tub or Legionnaire's disease dispute has adopted Farm Bureau's ingestion definition. In support of their definition, they can only rely upon this outlier case, Heineke, that adopts their preferred definition. Indeed, Farm Bureau's case largely rises and falls on Heineke, a case that's been cited only 4 times by other cases and never for the proposition that there is only one, that its definition of consumption is the only reasonable definition of consumption. Farm Bureau wants Heineke to bear weight that it has never borne before and simply cannot bear. It's also difficult, and Judge Murphy's questions pointed to this, to overstate how different Heineke is from the current controversy. Something that in closing, Heineke comments on. It says this is very different than hot tub cases. Instead of dealing with functional hot tubs, like the cases relied upon by plaintiff defendants, Heineke involves an art installation, a fountain in a hospital lobby that the court found served strictly aesthetic purposes. Art installations featuring water do not have economic utility in the same way that hot tubs circulating water for marketing and sales purposes do. Unlike the water in a hot tub, the water in an art installation does not constitute goods beyond the consumption.
Let me ask that. I don't think the appellant really hit back at that in their reply brief, but one of the things with fountains throughout history is that they're create an area that has cooler air. And part of that is, the water and the vapor coming from those. So to the extent, aren't we dealing with, while it's not to the same extent as the steam being important, coming from a hot tub for marketing purposes, but there is a cooling effect. There is an impact of the vapor for someone standing around the fountain when it's, 80 degrees in a building and it might be 65 next to the fountain. And doesn't that go right in line with why here the steam from the hot tub as a selling factor? Are we riding that same line?
I think you could interpret fountain in that way as being in some way analogous. I do think the broader context, especially the hospital lobby context, to a certain extent, pushes against that, Judge Murphy, because, at the risk of stating the obvious, nobody wakes up in the morning and says, I can't wait to go to the hospital. Even when, when I was sick with an appendicitis when I was a child, my mom and I didn't sit on the bed and say, gosh, which hospital shall we go to? Maybe the one that has a really pleasing art installation in the lobby. That's not how, to the extent there is an economic decision that's being made there, that's not how those decisions are made. So I think there is absolutely a world where even conceptualize the hospital fountain as having economic utility being a good. But in comparison to a hot tub that is not accessible, but is instead designed for a sensory bodily interaction to sell hot tubs, that is, if a fountain in a lobby is a falls within the consumption exception, then the hot tubs in this case fall within the consumption exception by a mile.
Ms. Brooks, let me ask, I took what you said at the beginning of your argument a little bit different than when I was reading through your briefs regarding the location of exposure. I took your brief as saying these people could have been exposed while walking around outside because it's already in the air. The appellees pushed back on that, given kind of the, I think it's some but-for language, proper cause language in the exclusion. But the way you poised it this afternoon seems to be a little bit of a change on that, in that the suggestion is that the exposure and it getting out amongst the fair could have occurred outside the walls of the Davis Event Center, which would take you out of the exclusion altogether. Is that how I understand? And if so, can you point me to anywhere that we could look and do a comparison test with any of the complaints in the record on that?
So what I would say is that, yes, the argument has changed based on the Farm Bureau's argument. We used the word exposure 6 times in the bacterial exclusion portion of the brief. We respond to the exposure, then relying on that exposure language. In the reply brief, they very clearly rely instead on the presence language. And the point that we're just making is that this is not nailed down to the Davis Event Center. And the standard here, and is it, Judge Murphy, is it the most likely way that people got region that's being transported in or out, water being maintained? Absolutely not. It's far more likely that people got it by walking by in the Davis Event Center, by visiting these hot tub displays, by ordering there for long periods of time. So the standard isn't most likely or even probable or possible. It's whether it's arguable or this court's opinion in Cuba. So it's just simply, I hope that answers your question.
But if it's water, I know Judge Wood looks like she's ready to ask something too, but if it's just the water as a good,
Yes.
is it arguable that the water in the hot tub would have ever been out and about the fairgrounds outside of being in the tub? I mean,
Yes. The allegations are that there was exposure at the fair. We're entitled to, and obviously, again, we know that these are there for display and operation purposes. They don't live in the Davis Event Center. They had to come in and out of the Davis Event Center. What that transportation entailed, I don't think we know at this point, but we're entitled to permissible inferences.
would it be a permissible inference that somebody would move a hot tub that's already full of water before setting in its location? It just seems,
I think it's
completely, to me, that seems a step beyond logic and reason. Somebody would fill a hot tub with water.
I think it's not likely, but again, the standard is whether it's arguable. But again, the argument, the court doesn't really even reach that issue because it's so plain false to that exclusion.
Mr. Burke, I have a question. Your colleague makes much of the fact that the complaints do not allege that the hot tubs were actually intended for bathing. They were just there for display. And so looking at your complaints, I did notice that I don't really see any allegations that they were intended for bathing, although a reasonable person might assume that a hot tub main use is for bathing. But his contention, of course, is that at the fair, they were just there for display. So how do you rectify or how do you address that?
Certainly, and what Judge Wood, the way I would address that is that bathing is certainly sufficient for Dillard House and the broader case law to establish that there's been bodily consumption, but it's not necessary to establish that there's been bodily consumption. Instead, these hot tub cases turn on whether there's bodily exposure to the hot tub water, whether it's being made available for bodily interaction, enjoyment, inhalation, even based on Farm Bureau standards, use or ingestion. So under any of those standards, principles decide cases with facts, not just facts alone. So you can't just point to a distinguishing fact and win the case. Those principles apply with equal force here, Judge Wood. And given these guiding principles, the facts of the current controversy really are materially distinguished because bathing has never been, these cases have never turned on whether there was bathing. And, whether we use, the case law speaks in terms of bodily exposure or use, degrading up of the water based on bodily interaction, inhalation, enjoyment. Those are not only it should be adopted by this course as not only the prevailing view of the jurisprudence, speaking to the fact that they're reasonable, but also they're the most insured friendly. And again, if you look at the pleadings that are common to all of these actions, the underlying actions of Hampson, it's beyond question that the victim's alleged bodily exposure to the hot tub water. It's beyond question that the hot tubs were circulating and degrading the water's quality for bodily interaction, for enjoyment, for inhalation. Again, Judge Wood, Bennett Carpenter could have just had an empty hot tub. He could have just had a picture of a hot tub circulating water. He didn't do that because he knew that was not the best way to sell hot tubs. He knew that the appeal of hot tubs is the bodily experience that goes along with hot tubs. That includes feeling the warmth of the hot tub. Again, keep saying this because it's exceptionally important. Having the refreshing mist on your skin, inhaling the refreshing mist. To the bathing point, Judge Wood, perhaps even running your hands through the hot tub water. If that was permitted, that's not only a permissible, but an entirely reasonable and natural influence, then the difference between this case and the water hot tub and hotel cases really collapses factually into nothing.
So where do we look to find those allegations? Where do we look to find those allegations that whether or not it actually happened that somebody's hands went through the water, but whether or not the hot tub seller, marketer, intended that to be a use? Where do we look for those allegations? Where do we find those allegations?
Are those, is the running the hand through the water?
I mean, I'm not saying that specifically,
But is that, I want to answer that, is that specifically alleged? It is not specifically alleged. I don't think that's surprising.
or maybe more broadly, are there allegations that that's the kind of experience
Yes.
that was intended to be delivered
Yes.
by this display?
Yeah, what we have here is allegations that these hot tubs were on display for marketing purposes. We have that the victims visited these hot tubs, that they lingered by these hot tubs for extended periods of time, that they talked to the salespeople associated with the hot tubs. Somebody purchased a hot tub. And again, I think we don't have to turn off common sense as to why these were circulating in the water. If it was exactly the same to have an empty hot tub in regards to moving, then certainly it would have been easier for the Carpenter to do that. Having circulating water, promoting that physical experience, I think, is just sort of implicit in a not only a permissible inference, but a natural inference from this. I'll also point the court to last year, this court decided Farm Bureau versus Lemire, and Farm Bureau versus Lemire said that in conducting the comparison test, we can also consider whether there was reasonable investigation, facts that could have been reasonably investigated and dispelled. That was reiterating something said in waste management, sort of central to this whole jurisprudence. Again, that there was intended to be a bodily interaction here, that hands could run through the hot tub water, that maybe could play around with the controls on the hot tub to have a different experience with it, because they're all not only natural, but certainly the standard is permissible. But in this case, if Farm Bureau believed that they wanted to dispel those inferences, or could dispel those inferences, could have investigated that, included that in their declaratory judgment action. That suggests to me they either did not investigate that, or when they investigated it, they didn't find anything that could dispel those points. So,
Ms. Brooke, you mentioned, and you're coming right up on your 5 minutes, but you mentioned Farm Bureau versus Lemire.
yeah,
I'm not seeing that in the briefs. Is that part of memorandum of additional authority?
No,
or
it's not.
is there a case citation for that?
I can submit a memorandum of additional authority given Judge Nixon's question about inferences and how we assess whether something is a permissible inference, it's a natural thing. to mention in response, but Judge Murphy, what I will do is when I get back to my desk this afternoon, I will put together a supplemental authority and a site. But also waste management, which is cited, Lanier is just citing back to waste management for that principle. So it's not a new thing to this. It's proven it's not new to the comparison test. It's really one of the changes. So,
Thank you.
in closing, this case is straightforward. I think Bureau and defense more broadly disagree on that. Defendant Carpenter was trying to sell hot dogs. The most effective way of selling a hot dog isn't a picture of a hot dog. One, circulating water. So patrons can feel what they're missing out on by not having a hot dog. Those defendants need only establish an arguable basis for coverage for bail. Their intended and actual interactions with these hot dogs fits comfortably within any of the definitions of bodily consumption that have been offered to this court this afternoon. And so the Farm Bureau's efforts to escape its duty to defend must fail. The plaintiff defendants and defendants more broadly respectfully request that this court affirm the ruling of the trial.
Mr. Brooke, let me ask just a couple of follow-ups along housekeeping lines. Do you agree with the summaries that are in the appellate's appendix regarding the complaints? Or based on your facial reaction, which may not be captured by the rest of the court, I would assume that you probably agree and disagree, but it's not a concession that that appendix is completely accurate. You would ask us to look at the complaint then? More specifically?
Well, Judge Murphy, I think what I would say is that I didn't see anything there that stood out as just wrong from those summaries. I don't want to sort of, as an officer of the court, just say that I agree with every word or every way something is framed. I understand those summaries, and I understand a lot of the Farm Bureau's argument to essentially be that this case is decided by the fact that, like Judge Wood and I were talking about, that these were in some ways displays as opposed to people having swim trunks on and getting in the hot tubs. I think that that is not really a fair character. These were interactive. We're not hands-off art installations. These were hot tubs that you were supposed to feed. So to the extent that they're sort of regarded as like hands-off displays, I just think that that is not borne out by the complaints or by common sense. And again, bathing, as I was talking about with Judge Wood, has never been where the rubber meets the road in regards to consumption.
And let me ask one more housekeeping question. I kind of said it while the appellant was arguing, but I took your brief to more or less be a concession that Legionnaire disease is caused by the bacteria. Is that accurate? And
Yes,
I know you made some just general statements regarding the other defendants' appellees. Are you also authorized or available to actually make that concession for them, or not?
yes,
You
yes, Your Honor. But on behalf of both defendant Carpenter as well as all of the claimants.
So nothing in our analysis or use of the comparison test needs to dive into that issue.
No.
Thank you, Mr. Brooke.
Thank you.
Good. Thank you, sir.
Thank you so much.
And we would be back with the.
Thank you, Your Honor. Could you reactivate the display, please?
Yes, we are back on.
Okay, what I would, let's see if we are. There we go. And let's go to the student. While the appellees didn't focus much on the exclusion, they failed to acknowledge that the exclusion applies. And I'd just like to spend a moment on that. I want to compliment counsel for trying to complicate what is simple by by details and arguments, but it really is simple. And it's not as complicated as they would have it. There are no allegations that hot tubs were moved in and out of buildings and there was exposure because of that. That is getting into the imagination again, that the courts don't allow us to engage in when we're talking about the duty to defend. So I just want to nail down, this exclusion applies based upon its very plain English language. And I've highlighted those words. This bodily injury would not have occurred but for the existence of or presence of the bacteria within a building or structure, because that's where the hot tubs were. That's the only place they were. There's no allegation anywhere that the hot tubs were anywhere else, or that they were transported about, or that there was exposure in the transportation of hot tubs. The hot tubs were alleged to be in the building. They were admitted to be in the Davis Event Center. And if there is Legionella from those hot tubs, it developed because of the alleged failure to treat and manage the water in the hot tub in the Davis Event Center. Now, the exposure to the Legionella in the Davis Event Center does trigger this exclusion. So it's sufficient, but it's not necessary. The exposure can be anywhere. It doesn't even have to be at the Mountain State Fair. On the plain language of the policy, as long as the core is that Mr. Carpenter failed to maintain the water in his hot tub, which is the core of their claim. That hot tub was in the Davis Event Center, and there's no allegation otherwise, no contention otherwise, no backup claims. And so the exclusion by its own plain language applies. And we focused in our reply brief on the existence or presence of, because the appellees raised the possibility that there was exposure outside the Davis Event Center, and that's very well true. But our point is, it doesn't matter where the exposure occurred, because for them to have a case at all, for them to be able to allege liability against Mr. Carpenter, it must be because he didn't maintain the water in his hot tub in the Davis Event Center. And with the court's permission, I would like to turn to the bodily consumption exception. And it's always a professional challenge and a pleasure to go up against such fine lawyers and arguing points that I would submit only fine creative lawyers could even think of to argue. I think back when I first heard about this case, and there was a hot tub, and people got Legionella, and there was a bacteria exclusion. My first reaction was, well, that's not covered. I mean, it's plain common sense. It's very simple. It's very simple. Only when we read a few several federal district court cases did the cases start engaging in this lawyerly analysis to try to create, in the context of hot tubs that were actually in use for bathing. All of those cases, hot tubs in use for bathing. Did the court say, well, and I'll disagree with counsel. I believe that every one of those cases deal, except those that dealt with people taking showers or drinking water from potentially contaminated water systems and hotels. But all of the hot tub cases involved hot tubs that were functioning in use for bathing. Now, not all people exposed were bathing, but some were, but they were optional. They were, in fact, in operation. I think it's helpful to, when we look at this plain language, this exclusion does not apply to any fungi or bacteria that are owned or are contained in a good or product intended for bodily consumption. We got to read it all together. Not just is it a good or a product, and not in some hypothetical is there some argument that there's consumption, but it's intended for bodily consumption. So all of those words count. All of those words count. And I would submit that sometimes it's important for us lawyers to stop thinking like lawyers and follow the rules that the Supreme Court told us to follow and think about plain language. And to help me do that, sometimes I apply what I call a Watkins grill test. I don't know if you're familiar with Watkins grill, the cinder block blue plate special place in Raleigh, but it could be Big Ed's or it could be Stamey's Barbecue here at Greensboro. But the point is, the Supreme Court says we use our common sense. We apply the plain language. We use it as a common language in common usage. And to imagine you go around to a table and there are working folks at one table, there are doctors at another table, there are law enforcement at another table. There's the whole cross-section of society. And if you went to each of those tables, would you imagine anyone would say that a hot tub, especially one just on display for marketing purposes, was a good or product intended for bodily consumption? I can't imagine that there would be a person in there who would say, well, of course, or I'm not so sure about that. We lawyers are brilliant at trying to create an ambiguity, but I submit the Watkins grill test is the test here. It's common sense, it's plain language, it's all of the words, and it's the words as used in common usage. It's common usage, it is consumption in its common sense usage of it, what the appellees would argue. And I'd submit the Heineke case, the case just expressly rejects that. I'll remind the court, the Heineke case is the only appellate court to address the exception. And that was the case involving the hospital water fountain. Now, we all know people put hands in water fountains that are not intended for bathing. We all know that. Sometimes kids go in there and put their feet, dangle their feet in. People get close to them because they like the mist, they like the cool air. But the Heineke case, and it's quoted in our reply brief, it expressly rejects the approach proposed by the appellees.
But that's part of the point too. That's the point in intended for bodily consumption. Whether it was actually bodily consumed is in some regards
exactly
immaterial. The question is, was there an intent for it to be?
Right. And are there any allegations that indicate that there was an intent? If there hadn't been exposure, and by exposure there's some consumption there, then no one would have been ill and no one would have died.
But that raises kind of, as these things tend to do, sort of can kind of cut both ways, where depending on when you apply that intent. You know, when are we looking at intent? Are we looking at intent in that moment where it was intended to be displayed? Or do we look at what is the intent of hot tubs generally?
Well, yeah. And I think in general, yeah, they're to be bathed in, but sometimes fountains are intended to be bathed in, right? So you got to look at a temporal, you got to look at what was intended at the time of the exposure, right? What was intended at that time?
Do you have any case law that backs you up on when we're supposed to be looking at the intent? The intent for the hot tub is just for bathing, or we have to look to see what the intent was at the time of the exposure? Do you have anything that backs you up on your analysis?
The only case law I have is a plain meaning reading, right? I don't have a case law that addresses that subtlety.
Let me ask you a question on this same path. And I've gone 17 years now since I got done with law school, and I haven't had to address the UCC. My recollection, and correct me if I'm wrong, is when we're talking about goods or products under the UCC, the legislature means generally talking about that good or product, and not necessarily a specific use. A good is pretty fungible. So if a good or product is intended for bodily consumption, isn't it the intent about the characteristic of the good or product generally and not specifically to how it's being used at this time. And if I'm misquoting the UCC, please let me know, but unfortunately, I didn't get my Wi-Fi logged in, so I was gonna look it up before I asked the question. I had the answer to. But, do you have any thoughts or response or different understanding of the UCC and its use of good or product?
It's been longer than 17 years since I was in law school, Your Honor. And so I can't, I wouldn't dare speak to what the UCC says or doesn't say. I think we don't look at technical language. We don't look at this language from a technical standpoint. So I would say the Supreme Court would say, Judge Hunter, don't look at the UCC to interpret these words. Look at them in the plain ordinary sense of the words, the way we use these words in our own normal conversation. And talking about a good or product intended for bodily consumption. Well, let's just be honest. We all know that's really foods and medicines, okay? And it's being stretched to apply to, for gosh sakes, a hot tub, and not just a hot tub that was being used to bathe in, a hot tub that was just on display. So they have pushed. And I admire them. They're outstanding lawyers, but they have pushed this so far that I've lost track of where we are here, because there is no case that goes as far as they ask it to go. I submit that the most persuasive authority is the only appellate court that has addressed that, the Wisconsin appellate court. And the best analogy is the fountain display in the hospital lobby. But even in that case, the word bodily consumption was not in that exception. The appellees have the burden of placing their case within the exception. Their burden is on that, not on us, right? We have to prove the application of the exclusion. They have the burden of showing the application of the exception to the exclusion.
And what do you say in response to really their footnote 4, page 22 of their brief, where they're saying, looking at Heineke, this is probably the fact that they have a different use of what they do if they find a term to be ambiguous, so they pick one, versus North Carolina, if it's ambiguous, we interpret it towards coverage. What do you say to that argument? Is that how you view Heineke as well, or do you have any response to kind of the background that Heineke was in jurisprudentially?
Well, and forgive me if I don't have their footnote memorized, Ron. But my recollection from the Wisconsin appellate court is their rules of construction are pretty much follow our rules of construction. I think that there was a difference, and they have a reasonable expectations standard, and we don't apply that. But our Supreme Court essentially says that we do, because we use we consider words as used in their ordinary speech, and we apply the plain language of policies. So we don't have a rule that it's reasonable expectations in North Carolina. The Supreme Court has never said that. So to that extent, I think their law is different than ours.
And you got about 45 seconds. Just answer. Do you have any other questions?
Well, thank you, Your Honor. It's been very interesting. I hope the law students have understood what excellent lawyers can do to make what ought to be a simple case a very complicated case. But I do ask the court to reverse and remand the decision of the trial court for entry of a judgment declaring the Farm Bureau has no duty to defend or indemnify. Thank you.
Thanks, sir. And I believe the intention, Mr. Remar, would be at rest for a few minutes while they change out the parties and change out the students.
All rise.